Good morning, everyone. For those that don't know, my name is Stephen Kelly. I'm Chief Executive of Manufacturing Northern Ireland. You're all very welcome along this morning. I'm joined by colleagues Mary Meehan, who looks after our people side of the work that Manufacturing NI do, and colleagues as well from Cleaver Fulton Rankin, law firm in Belfast. You're very welcome. The P word is a very topical word. I'm not talking about protocols or power or the pound, but people. People are at the center of all our businesses, whether you're in manufacturing or any other part of the economy. And we know how difficult it has been, particularly post-COVID, to get the right people with the right skills into your businesses. So the seminar this morning really concentrates on that area and how important it is and what the legal structures and frameworks are to assist you to get the right people into your business. And we know that every business across Northern Ireland is facing very uncertain times, and what they don't need is this challenge of getting the right labour into their business to ensure that they can continue to be successful. So today is very, very timely. We're very pleased to be joined by Suzanne Keenan and her colleagues from Cleaver Fulton Rankin solicitors. I'll hand over to Mary Meehan, who's the Deputy CEO of Manufacturing Northern Ireland, to take you through this morning's agenda. But just to say that the session is being recorded. There are some slides, and we'll share the recording and slides with you all who've been able to join us and the others who've signed up after the event. But do feel free in the meantime to put any questions into the chat function and the Q&A function. We'll try to endeavour after the presentations to get to as many of those questions as possible. And I know that colleagues at Cleaver Fulton Rankin are very keen to engage in providing you with the answers, hopefully, that you need.
Hi everyone, thanks Stephen. It's really nice to see familiar names on the call as well. Lots of our members that we would engage with on this particular issue. Stephen says, my name is Mary Meehan. I'm the Deputy Chief Executive of Manufacturing NI, and I work mainly on the people and skills and labour side of things. So it's been quite busy, I suppose, navigating the skills landscape and answering queries, especially in relation to the new UK immigration policy, and there's been quite a lot of queries from our members on this. So we are really pleased to partner with CF4 law firm on this particular issue on navigating the challenges and opportunities from business immigration, recruitment and retention. And labour and skills is a huge part of the work that we do through Manufacturing NI on behalf of our members. We engage with a very wide spectrum of stakeholders, including policymakers at both a local and a national level, and also on the education sector as well, to really inform and, I suppose, brief them on the challenges that our manufacturers face in relation to skills and how to really transform that skills landscape for the future to meet the needs of manufacturers. We also proactively engage with the Home Office, trying to mitigate really the consequences of the new immigration policy as well, and try and somewhat simplify the process for Northern Ireland manufacturers as well. But struggles with labour and, you know, getting a more skilled labour force, this has been bubbling up over the past number of years, certainly over the past decade. But with the pandemic and with the new immigration policy, this has really put a magnifying glass on it all and has really exacerbated those trends and difficulties that we are now experiencing, not just within the manufacturing sector, but in other sectors as well. So as Stephen said, this webinar is very timely and very, very relevant. We are increasingly seeing manufacturers deploying more innovative recruitment and retention policies, retention being a really a big buzzword at the minute, managing your own talent within your workforce and retaining that talent, because there is such a huge shortage of labour, and also really how to hire foreign nationals and navigate that quite difficult visa process. And CF4 Law has been very helpful with us on this journey and managing queries that we've put their way. So we're really delighted to partner with them. So with that said, I just wanted to pass over then to Suzanne Keenan, who is Director and Head of Cleaver Fulton and Rankin's manufacturing team. And Suzanne's going to be your host for today.
Thanks very much, Mary, and thanks, Stephen, for having us. We're just as delighted to be partnering with you as well. We think it's great, everything you do for the industry, so we're delighted to help out. So as Mary said, I'm a director in the firm. I work in the Employment and Business Immigration team. I also head up our manufacturing sector team. So we have a dedicated manufacturing sector team within the firm that is made up of solicitors across a number of disciplines, so across a number of different departments, who have a keen interest and passion in the sector, and also are very experienced in sector-related issues, legal issues, advising clients in those areas. So the team meet regularly. We meet every month, and we liaise in between those meetings. We put together newsletters highlighting and dealing with key legal topics in those areas. And we also do blogs, and our plan for the future is to start some podcasts as well. So again, it's all dedicated to the manufacturing sector specifically, and the legal issues that are affecting your businesses in that area. So I'm delighted to be joined this morning by a few members of the team. So Jonathan Braden, who's going to do our first presentation, and he's waving there, is a solicitor in our corporate and commercial team. And he's going to talk to you a bit around your commercial contracts and managing the risks and that are around product safety and liability. And he's going to give you some key tips in that area. Then I'm going to do a presentation on the importance of recruitment, onboarding, and your retention as well from an employment perspective. And then my colleague Nathan Campbell, an associate in the employment team, is waving there as well. You can see Nathan is going to talk to you around business immigration law, the current legal position and procedures, and some tips around the visa processes and things like that. So we've really put it together with what are key issues in your areas in mind. The idea is each presentation will probably take around 20 minutes. So we should have the presentations wrapped up within the hour, and we've left hopefully a decent amount of time at the end for question and answer, because we think that'll be beneficial for you to be able to ask us specifically in our respective areas, things that you need to know. We're hoping to get all the questions answered, but at the same time, please don't worry if there's something that we haven't had a chance to get to in the Q&A box. We will follow up with you afterwards if we have your contact details. So we will get an answer across to you. Without further delay, I'll hand over to Jonathan in the first instance for his presentation.
Hi everyone, nice to meet you. Thanks for coming along today. I am just going to start sharing my screen. Can I get a thumbs up from Suzanne if that's sharing? Okay, perfect. Okay. So yeah, nice to meet everyone. As Suzanne said, I'm going to be talking to you guys about product liability, product risk, and where that comes from, how you can manage it. And then I've also thrown together a little checklist that you can use to review your current contracts. But before we get into that, I would like to just talk a little bit about Cleaver Fulton Rankin. So Cleaver Fulton Rankin is a full service commercial firm. And what that means is that as a business, we can help you in basically any area where you might need legal advice. So my team, we would do a lot of transactional work. So that's, mergers and acquisitions, restructuring. We also do a lot of commercial negotiation, drafting agreements, negotiating agreements, that kind of stuff. And then of course we have Suzanne and Nathan on our employment and immigration team, but we also have dispute resolution and planning, construction, you name it. And I think, what sets Cleaver Fulton Rankin apart from a lot of the other leading commercial firms in Belfast is that we have basically a region leading private client department where our commercial customers can come in and in their individual capacity and, tackle their individual estate planning, inheritance planning needs. And that we give that sort of holistic approach to basically everything you can need as a legal consumer. And then a little bit about myself. So I worked in business development for a number of startups and a Fortune 500 company in Toronto before moving back home and qualifying as a lawyer. Personally, I've been involved in a large number of acquisitions, demergers, reconstructions, all that fun stuff. And my contact information, wrong way, is just below there. And as we said, we'll circulate these slides at the end. And if you have any quick questions and need some quick advice, please feel free to contact me. We're not going to shake you by your ankles for, you know, a 5-minute phone call or anything. We're very friendly. And so then on to today. Today we're going to discuss where your legal risks can arise from in B2B manufacturing contracts. So I want to give you some practical tips for how you can start to manage the risk in the negotiation phase. And then I've thrown together, as I said, a little checklist for you that you'll be able to take away and review your current contracts and maybe see if there's anything that needs work in there. And I just want to caveat my presentation today. This is a massive, complex area of law, and any one topic I touch on could probably be a series of lectures. But what I've tried to do is give you a high-level overview of the areas I think is most important, will be most important to the audience we have, and give you some practical tips that you'll be able to use in your day job starting from today. So with that, we will get started. The legal risks in manufacturing contracts. So when your business enters into a commercial agreement, it's accepting a certain amount of risk. And unless agreed prior to entering the agreement, you could be liable to your suppliers, to your customers, to their employees, and any third parties. And so what we're going to look at is what that might look like if an issue arises, what it looks like from a legal perspective dealing with it, and then how you might try to reduce those risks. So product liability for manufacturers is typically a portion based on fault and the ability to have prevented the damage or injury. So some of the most typical cases where this will arise in a manufacturing context are from product failure, poor product design, if your labeling is insufficient, you've issued incorrect instructions, or you fail to provide proper warnings. And so one of the ways that this can arise is through strict liability. So I'm not sure if you guys have ever experienced this, but strict liability is governed by the Consumer Protection Act, and it gives consumers the right to seek damages from a manufacturer, even if they didn't have a direct relationship with that manufacturer. And in order to do this, a consumer will need to show that the product was defective, that the consumer suffered damage, and that there was a causal link between the defective product and the damage. And the interesting thing here is that the consumer doesn't need to show that the manufacturer was at fault. What I mean by that is, if you're a manufacturer of a widget of several component parts, and one of your suppliers of those component parts has supplied you with something which then caused the damage, you're still on the hook for that. And that's why you're going to want to ensure that any commercial agreements you enter into with your suppliers account for any strict liability claims from the consumer. Another interesting point, just while we're on this, is that although the primary liability will rest with the manufacturer, you can be held out to be a manufacturer if you are if you put your own brand on something, or if you import something into the UK, you can potentially be held to be a manufacturer under the Consumer Protection Act. So again, just something to be aware of. And obviously, the big issue with strict liability is that it's going to be focused on the nature of the product itself, whereas when we're dealing with negligence, on my next slide, it deals with the behavior of the manufacturer. So negligence is essentially any act or omission which falls short of the standard that would be expected of a reasonable person. And a claim of negligence can be made against any party in the supply chain if their actions were negligent and then caused loss or harm. And usually in this context, a claim of negligence will be brought directly against the manufacturer from either a distributor, by a consumer. And in order to bring a claim, they would need to show that the manufacturer owed a duty of care, which in this case, as a manufacturer, you will owe a duty of care to your end user, and that you breach that duty somehow, and that the breach caused damage. And then obviously that the manufacturer could have foreseen that damage taking place. So say that could be a faulty product that's been passed down the line, that can come back to get you in hot water. So that's strict liability and negligence. And then probably the most common one that we'll see in sort of B2B relationships would be breach of contract. So any party along this sort of supply chain can be liable for a breach of contract. So essentially all your contracts are going to be made up of express terms and implied terms. Express terms will be the things that are actually written into your contracts, whereas your implied terms can come from a variety of sources. So that can be statute, can imply terms into your contracts, your course of dealings, which we're not going to deal with today, and then case law. So the courts can actually imply terms into your contracts as well. So obviously within the context of manufacturing, some of the most common breaches will be for that the goods aren't fit for purpose, they're of unsatisfactory quality, and they don't match the seller's description, which ties in neatly with some of the implied terms, which you guys may be familiar with. So as I said, terms can be implied into a contract from both statute and case law. And from statute perspective, they come from the Sale of Goods Act, and this governs anything where there's a supply of products. So they will apply three main terms into every commercial contract. One is for the quality and fitness of the product. So the quality must meet a reasonable person's standards. And the fitness for purpose aspect is quite interesting in that if a buyer lets you know the end use of a product that they're buying, you actually have a duty to make sure that those products fit that end use. So it's just an interesting obligation on manufacturers there. Sale by sample is relatively straightforward. If someone's entered into a contract based on a sample, and then that is going to have to correspond with any subsequent goods provided. Sale by description deals with the technical specifications of a product. So if you are selling goods, you just need to make sure that the actual goods themselves match with both the technical description and the sample, and that will be automatically incorporated into any contract, as I say. And then one other thing I wanted to highlight is that case law can also be used to imply terms into your contracts. And this area of law isn't maybe as publicized as statutory implied terms, and it can actually develop a little bit quicker as well. Sometimes fly under the radar, which is why it's important to have a good solicitor. So just for this case, J. Murphy and Sons v. Johnson Precast, it was actually ruled that specialist manufacturers or specialist suppliers have a legal duty to proactively warn potential customers about known problems with their specialist goods. So I just thought from a commercial perspective, that could be interesting, and that you might have to proactively warn purchasers about the deficiencies in your product, and it's actually a legal obligation to do that. So just wanted to flag that to your attention. And then, so as I said, I wanted to give you guys sort of a high level review of some of the areas where problems can arise in manufacturing contracts. And now I'd like to give you some somewhat practical tips on how you can reduce the risk of those happening in the negotiation phase of contracts. So you do have the potential to exclude liability entirely, or to a certain extent, for certain types of losses. A well-drafted contract can exclude liability for breach of contract, claims of negligence, or a loss which is too remote. You can also exclude indirect losses, which would be things like the loss of profit, loss of business, expenditure, legal fees. All of that can be dealt with in a well-drafted contract. But it's important to note that you can never exclude death or personal injury caused by negligence, liability, or liability for selling goods that you don't have the good title to, which means you have the right to sell them, or for defective products. And from a drafting perspective, from a legal perspective, if your contract is poorly drafted and you try to lump some valid exclusions in with some invalid exclusions, the entire clause will be void, and you risk being liable for everything. So again, just if you are ever entering into negotiations, probably a good shout to have a solicitor take a quick look. And just something that I thought may be of interest to the audience we have today is that under the Unfair Contract Terms Act, if Party A enters into agreement with Party B, and this would typically be where Party B has much more commercial negotiating power, and you have to use Party B's standard terms. Their terms may say expressly that we exclude liability for our own breach, or we can give you X if you've contracted for Y, but that would actually be void. But it's something that you might see from sort of the big players in a small pond trying to sort of push their weight around on the smaller players. But just something to be aware of as you guys move forward. So another tactic you can use to reduce risk would be to place restrictions on a buyer's rights or remedies. So as I talked about before, the Sale of Goods Act implies certain terms into all commercial contracts, and a breach of those terms will automatically give a consumer or a contractor the right to rescind that contract. And obviously from a commercial perspective, that's not going to be great, because if you have, say, for instance, you've entered into agreement to supply roof tiles, and 99% of these roof tiles have been great, and then one batch goes through and there's an issue and you're in breach of an implied term, the party you've contracted with can have an automatic right to just rescind that contract, and you start again from scratch, and obviously from a worse negotiating position. So what we would recommend you do is you acknowledge the existence of those implied terms and build on them, sort of flesh them out a bit. So you can give the contracted party the right to have products repaired, replaced, or refunded, rather than just an automatic right to totally rescind that contract. So again, that's just another practical tip for you guys when negotiating. So, and then I think one of the strongest ways you can protect yourself when you're entering into commercial agreements is to get indemnities for specific events. So an indemnity is a promise to protect the indemnified party against the loss by paying money on the occurrence of a specified event. So these are usually quite contentious, and they create a liability on the indemnified party to pay every penny of a loss, where a court might actually provide for a smaller amount. So these can be very contentious and provide great protection to the indemnified party at the expense of quite a substantial risk of the indemnifier. So one thing I would say is, if you're ever asked to give an indemnity in a contract, the first thing you should do is contact a legal advisor. It doesn't have to be us, but you should definitely contact a legal advisor. If you don't want to do that, then I would just ask that you keep these things in mind, that if you are going to give an indemnity, you need to limit it to things for which you're directly responsible and in control of. And you're going to want to ensure that it contains a financial cap. And you're going to want to also ensure that the indemnified party has to comply with certain requirements on your end. So that will be things like, if a claim does arise, who's going to have final say in how that claim is managed? Should probably be you. You're going to want to ensure that the indemnified party has to give you notice that a claim has arisen in a specified form, whether that's, a solicitor's letter or email to a specific address. And then you're also going to want to include a duty on the indemnified party to try and mitigate any losses, so that they can't just run up a massive bill by leaving things sitting for 6 months that you then have to pay. So yeah, that's the indemnities. And then I also just wanted to give you some additional quick wins, I guess is probably the best way to say it. So these are things that probably shouldn't be too contentious. It can be worked into many commercial agreements, which will reduce your risk by even 1%, but for a solicitor, that's a win. So licenses and consent obligations. So you can work into a contract that any distributor or supplier will have to obtain and maintain certain consents or licenses, which will reduce your risk and exposure to liability there. If, on the other hand, you're being asked to obtain a license for commercial reasons and you're not legally obligated, we would advise that you could always negotiate back that the cost of obtaining and maintaining that license is borne by the person asking for it. And then, so things like sampling obligations and packaging specifications. So you can work those into a contract to make sure that you're in control of how things are sampled, or that a distributor samples things before they're sold. And packaging specifications, you can use that to prevent any repackaging or compliance with statutory provisions or obligations in your local jurisdiction, or maybe it's in mainland GB, and you would want to have your distributor over there be responsible for the compliance with their statutory provisions. And then product information, so ingredient labels, stuff like that. Who's going to be responsible for providing that? And depending on what jurisdiction your products are going into, you might want to be responsible for that, or you might want your distributor to be responsible. And so that's just all things that I wanted to give you guys sort of practical considerations, where if you're going into contract negotiation, you can sort of use this as a bit of a checklist as you move forward. So that was basically it for the presentation. What I've done is I've just drawn up a bit of a checklist for you guys that will be included in the presentation when it's sent out. If you guys are engaged in any contract reviews, you can use this as a starting point. And if it causes any red flags, then you might need to renegotiate that contract. You might need to instruct a legal advisor. But as I said, we'll include this in the presentation that's going to be sent out to you guys. And so basically that's it for me. I might not be around at the end to answer any questions, but we have a director on our commercial team, Stuart Sproul, who will be. So I will stop sharing my screen. Thank you very much for listening to me. I'm sure that was one of the drier presentations you've had to listen to in your life. So I appreciate your attention, and I hope to meet some of you guys soon. Thanks very much. I'll hand over to Suzanne.
Thanks very much, Jonathan. I think you're far too hard on yourself. I thought that presentation was really good and really informative, and I think that checklist as well is great, and hopefully that will be beneficial to some of the participants in terms of sort of highlighting any red flags. So now I'm going to do my own presentation, just in case any of you. So what we're doing is we're using our slides as our background. So you should hopefully, if your view is set up correctly, you should have us as the big screen, and then you should be able to see the bullet points behind us. If anybody's having trouble with that, message us into the chat. But it should be in your view settings. If you check standard view, once I start sharing, then hopefully you should be able to see my full presentation behind me. But as I say, if anybody's having issues, just message into the chat and one of our team will answer and give you some instructions as to how to see those. The presentations will be shared afterwards as well. So don't worry if you're trying to get notes or anything, don't worry about that. We'll get them out to everyone. So I'm just going to share my screen now. So hopefully you can see that. Maybe Nathan, I can see you on the screen. If you could give me yep, okay, great. So as I covered earlier, I'm a director in the Employment and Business Immigration team. So this area of recruitment, onboarding and retention is something I'm particularly passionate about. So as employment lawyers, you can imagine that we see it from lots of different angles. So we obviously advise on employment law to our clients, but we see a lot of practical things as well that are good tips for clients in terms of managing sort of the recruitment, onboarding, retention piece. And we wanted to share those with you. Both from the legal perspective, but also from a sort of a practical business perspective too, because as you see there, our motto is legal excellence and commercial sense. So what I'll be covering is I'll be covering recruitment, I'll be covering onboarding, and I'll be covering retention. And the retention piece sort of touches on flexible working a bit as well, because that flexibility piece has come up a lot recently in terms of home working and things like that. And then, as I said, at the end of all of our presentations, there'll be an opportunity to ask me any questions that arise out of the presentation. So why is this so important to your business? Ultimately, I think Mary and Stephen both covered it really well in their introductions, that we appreciate that people is a core piece of your business, and that being able to attract and retain and get the best out of your people is something that's really important to you in the manufacturing sector. So if you have problems with this area, it means you'll not be able to grow your business, because if you can't attract the staff to do the work, the right staff to do the work, then you'll really struggle to grow and compete in the market. It can also cause issues with retaining existing staff. if there are shortages. So I think I might have just skipped past it there. There we go. The statistics at the minute overwhelmingly outline that there is a huge skills shortage in Northern Ireland across many sectors, and I know manufacturing is a sector that's been hard hit by this. So if you have a staff shortage, it kind of has a knock-on effect in terms of the retention of your existing staff, because they're struggling to keep up with the workload. And then also you have that financial and reputational issue around recruitment that can be caused by the revolving door. So if you have a reputation as a business that is having a very high staff turnover and you're losing staff a great deal, then that can cause you a big problem in terms of attracting new staff. So this is a huge statistic. I thought this was really, really telling. So currently, or certainly recently, 69% of Northern Irish firms believe there is a skills shortage within their organisation. I mean, that number is just absolutely huge when you think about it. So it is affecting lots and lots of businesses across many sectors. In terms of recruitment, what sort of advice can we give you? So this is kind of your first stage of the process. So if you think about really your employee from the very, very earliest stage, you have exposure to them. It is the recruitment process. So some sort of key tips from us that'll keep you right from a legal perspective, but that'll also be really helpful to you in terms of that retention and onboarding piece. And doing recruitment correctly is identify the need in plenty of time. We know everybody's busy, but unfortunately, rushed or last minute recruitment exercises, they leave you very disadvantaged because you end up operating in a small pool with a limited window of time, and your process hasn't been properly prepared. So it can be a bit disorganized. So it is best to be regularly asking yourself, even if the need isn't jumping up and down and screaming in your face, is to be regularly asking yourself as a business, how you are managing in terms of workflow, and are there any gaps that, while they might not need someone now, they might need someone in 4 to 6 weeks' time. Then once you've identified need, create an accurate job role or specification. So again, this is good preparation for your recruitment process. A lot of candidates will look for this whenever they're scouring for jobs. And because you are in an employee's market at the moment, you need to be, thinking about how you attract those individuals. So they will look for job roles and specifications, and that will also help you make sure that you're getting the right people in through the door who are, interested in the specific specification you're looking for. I think a lot of people tend to ignore vague job descriptions. So the more information really you can put in that, the better. Getting it done right is important as well, because you want to make it clear that the job description is a guide and is subject to change. You don't want to be nailed to exactly what's on the job description, and then if you go to ask an employee at a later date to do something else, they revisit the job description. So that will be done properly in your later contractual documentation, but it is good as well, good practice to put on the specification that it's a guide and is subject to change based on business needs. Ensure any advertisement is clear and non-discriminatory. So again, make sure it's clear in relation to the job role you're advertising, and make sure there is nothing in it that could be deemed to be discriminatory in any way. Most businesses are pretty switched on about this now. I mean, I've seen some newspaper cutouts from decades ago that would just make your heart stop as an employment lawyer. Most businesses are good about their advertisements. But what I would say to you is, if you're in doubt about any of your criteria that you're putting on your advertisement, get legal advice on that, because some things might not be obviously discriminatory to you, but a good employment lawyer will keep you right and say, oh no, don't put that in. That is arguably discriminatory and you don't want that kind of heat. So the other thing to be mindful of is equal opportunities monitoring. So in Northern Ireland, this will affect anybody with 11 or more employees. So you have duties under equal opportunities monitoring in terms of monitoring candidates. It doesn't matter whether you in the end don't actually offer them the job. You have a duty under the equal opportunities monitoring to get the monitoring forms filled in by potential candidates who are applying for jobs. You also obviously have the duties as well in relation to your existing employees in terms of reporting. So again, if you're not sure about any of that, there's good information about it on the Equality Commission website, and a good lawyer, again, will keep you right in terms of your duties. Train staff who are involved in shortlisting, interviews, decision-making and communications. We see this a lot in subsequent litigation. One of the things that the tribunal a lot of the time are very interested in is how much training staff have done in terms of interviewing individuals and doing recruitment exercises. So it is really beneficial to have that, have a record of that you've trained those individuals. It's also good from a PR perspective because you show a really organised front. If your staff are trained in how to do interviews, they're likely to do them very competently and a lot more confidently than if you sort of just throw them in at the last minute and they're not really sure what they're allowed to ask and what they're not. Good training will also prevent those what to a lot of people what they consider innocent questions, but that can get you in hot water. Like, for example, does someone have children? Asking questions like that. Those are the types of things that will get you in difficulty if somebody makes a discrimination allegation. A good training and record of the training, and even bullet point list for those staff to revisit before they go into an interview, will help you hugely in relation to that. Have a clear procedure for your shortlisting. So again, we would recommend having a clear and fair selection criteria as to how you are going to shortlist the candidates who have applied for interview, and use it. So don't just have it there. Make sure your staff are actually applying it to the candidates. Again, if you're developing criteria and you're concerned that anything may be discriminatory, or you just want somebody to have a look over it, do run it past a legal team. One of my favourite sayings, and the guys will probably be rolling their eyes now, is because they've heard it in every presentation I've probably ever given, but a stitch in time with this really does save 9. A few minutes to pay a lawyer for a few minutes looking over documents, as opposed to coming along and saying we've had a claim from this candidate who didn't get a job and maintains that our selection criteria was discriminatory. It just makes sense. It's far easier to get it checked before you roll it out and before you're using it than coming along afterwards with the big ugly problem. That's a lot more difficult to fix. Have a plan for your interview and have set questions. So again, well-organised interviews go across far more impressively to candidates than sort of disorganised flaps where nobody really knows who's supposed to be in charge of the interview. Nobody knows to do introductions, for example. Nobody knows who's asking what questions. The questions are off the cuff and maybe not entirely appropriate, or potentially worse, discriminatory. So again, if you have a plan for the interview and you have the set questions, again, that will give you that bit of protection. And it'll just look a lot more impressive to candidates, because you have to remember as well that in a labour market where there's a shortage, you are putting on a show as well. This candidate may have other options, so you want your whole process to look really slick and professional. This one's really important, I think. Ensure all applicants receive a standardised outcome communication in writing. One of the things I think you hear a lot about candidates from recruitment processes is that nobody ever got back to them. They never actually knew the outcome. And I think that's, unintentional by businesses. You're all very, very busy. And also a lot of the time you'll want a clear acceptance from the successful candidate before you will cut loose all the unsuccessful candidates. So I think a lot of the time it is just completely accidental where you're waiting until your successful candidate accepts, and then maybe there's been a passage of time and you forget or you don't get round to issuing outcomes to the other unsuccessful candidates. The one thing I would say about that is today's unsuccessful candidate, maybe somebody in 5 years' time or 2 years' time you really, really want. And I just think if they'd go through a recruitment process, particularly if they attend interview as well, and they don't hear an outcome, it leaves a bad taste in people's mouths, and you may find that if they see an advertisement for your organisation in 2 years' time and they're your dream candidate, they might not apply because they might think, oh, I went through a whole rigmarole the last time and I didn't even find out that I was unsuccessful. I just had to assume when I hadn't heard anything. So do try to have a good process of having a very simple, short outcome letter confirming the position to unsuccessful candidates as well. Maintain records. So again, It'll not surprise you to know that lawyers love you having records of these things. So records of training, copies of applications, copies of selection criteria, because that is hugely beneficial and advantageous to you in the event you do face any criticism or indeed litigation. Those records will protect you. Obviously, from a data protection point of view, you only retain them as long as you need them. But certainly you could take advice on that in terms of what is a good period of time to retain those kinds of records, and be consistent. So again, if you have a good procedure in place and you're consistently following it, that will look very professional. And consistency as well is a great system to have, and will protect you against arguments of unfairness or discrimination. You ran a really detailed and protracted recruitment exercise for job X, but job Y, so and so just got it, and it was not a proper process. So look, just to avoid you getting complaints or grievances or gripes in from existing employees, and or facing any criticism, in a litigation perspective, it is good to make sure you're being consistent with all your recruitment exercises and following your process. Risks of a poor recruitment process. So obviously failing to attract the right candidates. If your advertisement is vague or inappropriate or says something it shouldn't, then you might not attract the people that you're looking for. Applicants may also disengage before interview or not accept offers if they feel a recruitment process has been unprofessional, disorganized, or delayed. What you have to remember is this individual may be interviewing with you today. They may also be interviewing with 3 other organisations this week. So if you are a bit lackadaisical about getting your second interview arranged or getting back to people or sitting down with your team to make a decision, you may well be missing out on key candidates that you were really interested in. Reputational damage. People talk, and we see this in a lot of industries that candidates do talk about interview processes or recruitment processes they've been to, and they could be putting off people who've never even had any exposure to you, where somebody says, oh, I saw an advertisement for so-and-so, and somebody says, oh, I wouldn't bother, I interviewed with them, they were weird, or they were really disorganized, I didn't hear back for 3 weeks, or things like that. So remember that we live in a small jurisdiction, and people do talk. So it's about your reputation as well. And then obviously, really, really bad case scenario is a claim of discrimination against you. So individuals don't need to be an employee of yours to make a claim. Unsuccessful candidates can also make a claim of discrimination in the recruitment process itself. So you are exposed. So here are some very unpleasant headlines that you really wouldn't want your organisation being associated with. You had the consulate one, was a mother who was asked during interview about her childcare provision. Lots of questions about what childcare she had in place and how she had it sorted, and she made the argument that wouldn't have been asked of a man applying for the job. So she was successful in her claim, and she was awarded compensation. Now, the compensation amount there is not huge, but you have to also factor in the fact that the 2 parties would have incurred significant legal fees. So you would also be, paying your legal fees associated with the case. And then I suppose you're dealing with a headline like that, potentially in one of the media outlets in Northern Ireland with your business name in it. It's just not great. And it isn't going to do your reputation any favours. And you are then risking people, both existing employees and potential future candidates, being really put off from you as an employer if they read something like that about your organisation. The other ones are pretty self-explanatory. Age discrimination and religious discrimination. So there are things you really need to be mindful of. The media do love employment as an area for stories. So, these cases do tend to find their way into media outlets. So it is important to consider the risks carefully in terms of the reputation of your business. So onboarding, you've done your recruitment process, you've got your candidate. My watch was just talking to me there. You've got your candidate, and you are moving on with now your onboarding process. So you're really happy with the candidate, you're excited, you're really interested in getting them to start. I'm afraid you're not done. So, don't do all that wonderful work impressing the candidate as the recruitment process and then have them turn up in a really sort of mismanaged, disorganized way, where they don't know what they're doing. Your team don't know why they're there. They didn't know they were arriving today. They didn't know they were starting. Because you start to undo a lot of that work where you've shown yourself to be a really organized together employer who's on top of their paperwork and their employment law. So if it's done badly, it can result in higher anxiety for a new employee and a direct impact on their productivity. If people come into a new organisation and they don't feel like they've been properly onboarded and mixed in with their team members, they can be anxious and it'll affect their productivity. It also suggests that you don't prioritise people or people management. So again, you've done this really good work in the recruitment exercise, but actually, they've started and you haven't really bothered to do much around their onboarding and their integration in the team. It just gives a bad impression of you as an employer. You risk the new employee leaving as a result of a disorganised onboarding process or miscommunications around onboarding, for example, giving them the wrong start date. Or again, not telling other staff they're starting, or as a result of that, there being issues with their integration. You do risk where the labour market is buoyant and there are other opportunities for that individual, you risk them going very quickly after starting. And then obviously the risk of poor integration, how that affects existing staff. It can be very destabilizing for your existing staff if new people are coming and going and they're not being told. So communication is key here, and making sure you let your existing team know, okay, we're really delighted to announce that so-and-so has been successfully appointed to this role and is starting on Monday, the whatever of October. And we're looking forward to welcoming them, and their role will be this, and they'll be working with whoever. And then having those conversations with the people that they're going to be working closely with so that everybody knows the position. It helps people feel less threatened as well. I think people sometimes feel threatened if somebody comes in and they don't actually know what their role is. Organisations with poor onboarding programs have twice the chances of experiencing employee turnover. So it is definitely something you need to be thinking about. How to onboard professionally then. So here are some sort of our best tips in terms of sort of keeping you right from a legal perspective, but also the practical implications around onboarding and how you can do it really well. So with your offer letters, we see less of these, to be honest now. It used to be very, very common to issue offer letters and then not to issue a contract until after the individual has started. That has become a thing of the past because more and more candidates now will ask for the contract up front. And also in terms of making the process simpler for you, it's better to just have the contract ready, because what you end up having with offer letters is you have to make sure the offer letter is very carefully drafted so that it's consistent with the contract. And you also then need to make sure the offer letter is clearly subject to the contract, i.e. if there's something in the offer letter which suggests something that's actually not in the contract, that the contract trumps the offer letter, if that makes sense. So from a process point of view, it's easier. They are still appropriate, I think, sometimes where an offer is conditional. So you're not ready to issue the contract because the offer is conditional on some of the things the candidate needs to do for you before you can offer them the contract of employment. So again, just to ensure your offer letters are clear in their terms and that they're made subject to the contract. When should you issue a contract? So our advice is, look, the sooner the better. As I said, a lot of candidates will look for it. You can, of course, issue the contract before their start date. Their start date will just be reflected in the contract as a date in the future. But you can absolutely send it out to them before they start with your business. And we would actually say that's better because you've plenty of time then to get it signed, get it back, get it onto your HR file. Also, if there are any issues or questions arising from the candidate in relation to the contract, you've got plenty of time to get those dealt with. Article 33 of the Employment Rights Northern Ireland Order 1996 provides that a contract must be issued to employees within 2 months of the commencement of their employment. Not a lot of businesses realise that that is a statutory duty that you have to send it out. In terms of the risks of breach, if you don't issue it out, it can result in additional bolt-on claim being brought by the employee. Now, it can't be brought as a standalone claim to the employment tribunal, but it can be bolted on to other claims, and it can result in an existing award of damages if you haven't issued them a contract. But in general, as I say, the 2-month rule is what's provided by statute, but we would say, look, there are risks with late contracts, and given candidates look for them in advance, we would really recommend that you go ahead and get those out sooner rather than later. What are the sorts of things you should include in a contract of employment? So there are obviously the basics, and I've done sort of a short list there, identifying what the basic and key things you must include are. So the obvious ones: names, pay interval, hours, holiday, sickness, things like that. You shouldn't include full policies or procedures or things like that. Those are things that should go in your handbook, because those are things that you will want to be able to amend. The rules around contract provide that once a contract has been agreed, so your employee has agreed it, you cannot amend it without their consent. Now, there are other ways to deal with that point in terms of getting implied consent and things like that. And we actually have recently done a blog about that if you're having that issue or having that concern. But bottom line is, it is complicated to get it amended after the event. So you don't want things like policies and procedures in there, because you want to be able to change those. You want those to be a bit more fluid. Additional clauses you need to think about in the contract: probationary period, confidentiality provisions, restrictive covenants. So restrictive covenants are things that limit the employee's actions post-termination. So things like not to contact your customers for a certain period of time after termination. They're not always appropriate, because it's a balancing exercise. They have to be in line with the business protection. You can't just slap in really, really limiting covenants that actually don't mirror the level of input that individual had in your business. But again, a good legal team will advise you on appropriate covenants that give you the best protection in terms of post-termination restrictions. Things like intellectual property rights, training clawbacks. If you're going to invest a huge amount of money putting somebody on a course, you want to have potentially training clawback provisions scheduled to the contract. Things like garden leave and their obligations after termination. This one, the bottom one, is it's easy to forget. Some businesses are brilliant at getting the contracts out, but not necessarily following up to get them signed and back from the employee. So from a legal perspective, it's obviously best to have a signed contract of employment on the file. So do follow up with your employee and get a signed copy back. The handbook. So when should you provide a handbook to your new employee? Again, with the contract would be our view, because the contract will refer to it. It will talk about disciplinary procedure, and it will refer to the handbook. So again, most candidates and employees will ask for the handbook when they get a copy of the contract, and you want to look organised. If they ask for it and you take 2 weeks to dig it out of somewhere, that doesn't look great. So I think it's just easier to have it ready to go. And if you have a good legal team who have prepared a good set of a good suite of HR documents for onboarding, you'll have all this at your fingertips, and it'll be ready, and it'll look really professional and really slick, and it will be drafted with the protections of your business in mind. This point at the bottom I've already covered. You don't want, it'll be very clear in the handbook if it's well drafted. It'll be very clear that it's not a contractual document and it is subject to change by the business. Practical tips then. Have a planned induction and itinerary and issue it to the employee in advance of their start date. This just looks great. If you're a new employee due to start and you get from the HR director or from anybody else in the business a rough itinerary of what your first day is going to look like, that you're going to do your IT onboarding from 9 to 11, that you're going to meet the CEO for coffee, or that you're going to meet your team for lunch, and then that you're going to do training on the software or training on the machinery or whatever between 2 and 4, and then you're going to have a coffee break or whatever. It just puts your employee at ease before they come in. It also gives you a bit of a structure in terms of starting it, and it gives you something consistently to follow for onboarding other employees in future. So if you have a sort of a rough itinerary and guide for inductions, it's really, really beneficial. We recommend including something social in it. Again, it just helps you integrate them into their team. So like a team lunch on the first day, or sitting with everybody for the coffee break or something like that, just to get to know them personally as well. Get the balance right too. Don't overload them in the first few days. So maybe you've been really short-staffed and you've really struggled, and this person's starting and you need a load of time made up. But be careful about that. Bear in mind, they're new to your organization. They're learning how your business works. They're maybe getting trained on machinery. They're maybe getting trained on software. If you overwhelm them, that can be counterproductive. At the same time, don't have them sitting in a corner with nothing to do because you forgot they were starting. That can be pretty demotivating as well. So try and have a good layout of work. And also, if you obtain feedback from employees who you've run through the induction process and you said, how did you find that? Were the first few days very busy, or were you overwhelmed, or whatever? It'll give you something as a guide then to go back and revisit and say, maybe we've sort of packed too much in on this first day, the first week, or whatever. We maybe need to space this out a little bit more, or maybe do some of the training the following week, because the feedback from the employees has been that there was a lot to take in on day one, things like that. It'll help you sort of develop it as a system going forward. Ensure your other staff know they're starting. I covered this earlier. If somebody starts and the reaction of your existing staff is, who are you? That can be a bad impression for your new employee coming in the door. And as I said, it can be destabilizing for your existing staff because they feel they haven't been communicated with about this new individual. So retention then is the final topic I'm going to cover. So you've recruited, you've onboarded, you've good people in your business. And what we've heard from a lot of businesses recently is they're really, really struggling with the revolving door. They're really struggling with retention. They're going through a lot of expense, time and effort to recruit skilled individuals into their teams, and they're not retaining them. They're bouncing on very quickly, sometimes within the year. And as you know, for a business, given your bedding in periods and all of that, that can be a big hit financially, because you're not necessarily getting the benefit of that individual's expertise. You're not getting the benefit of the time you invested training them. So retention can be a big, big problem. In terms of, I think this is really helpful, this diagram, because it's very easy to overlook the potential business expense. Because I think as a business, if you think about, well, I'm recruiting like for like, I'm bringing in somebody on the same salary, so it hasn't cost me anything that this individual has left. It's been a bit of an inconvenience, but it hasn't been an expense. I think, unfortunately, that's a bit of wishful thinking, because if you look at this example I've done, it's a rough sort of scenario of a £30,000 per annum employee who generates maybe £60,000 per annum turnover for you. So for example, let's say this individual works in sales for you. What does that cost you as a business? So the first line is the outgoing employee and their notice period. So they'll usually have somewhere between 1 to 3 months. I've put 3 months down here, but they'll usually have 1 to 3 months of notice period to do for you. It's totally unrealistic to think that this individual is going to be at full tilt throughout that notice period. A lot of it will be handover and scaling back. They're not going to be taking on the same level of work that they would ordinarily for you. So if you look at that at 50% of their usual efficiency, it gives you that expense to the business in terms of lost turnover. Recruitment fees, again, if you're using a recruiter to replace that individual, recruitment fees can be 20% of the new salary. So you're looking at £6,000, and that can be a chunky piece of change. Recruitment time of key staff. So again, a lot of businesses overlook this. If you've got some of your directors at the top of your business having to set aside time to work through CVs, criteria, set up interviews, attend interviews, do feedback interviews, and make decisions, that's a substantial period of time, and that's assuming you only have to run the recruitment exercise once. We've heard from a lot of clients that they're having to run recruitment exercises on a number of different occasions to get the right individual. So, it can be a lot of time. So you're talking maybe 40 hours of lost productivity. Now, I've calculated that at a higher rate, presuming it's higher members of staff in your business who are responsible for the recruitment exercise. And you're looking at potentially around £10,000 of lost turnover from those individuals. Your incoming employee, they're going to need to bed in. In the first 1 to 3 months of their employment, they're not going to be at full tilt. They're going to be operating on a lower level of productivity than they will when they get up to speed. So again, you're losing a bit of turnover there. Okay. Business reputational damage. and lost turnover. So having a reputation as a revolving door, or the impression to your clients who these individuals have built a relationship with, the impression of, right, okay, and now you have so-and-so, that can do damage. And I've probably been quite low in my estimate of that, but I put that down as roughly about £10,000. Bottom line, that takes you out at quite a chunky amount of money that this individual leaving has cost you, in them leaving and then replacing them. And this is assuming you have replaced them relatively seamlessly and you haven't had a gap and any other issues caused by that. So that's a huge amount of money. And the other thing then to consider is they do have a ripple effect, resignations. You do tend to find as a business, a couple tend to come in a row, because one person resigning can prompt other people to think, oh, well, here's so-and-so got a job wherever, I wonder should I be looking? And the next thing you know, then you've another resignation in a few weeks later. And unfortunately, that could potentially bring you back to the top of that calculation to do it all over again. So it can be very expensive to have that retention problem. What can you do about it? So you need to be thinking about what are the top reasons employees leave. So setting aside sort of financial drivers and salary and things like that, these are from a recent study as being the top reasons employees leave. So feeling underappreciated or undervalued, burnout, work environment or culture, the relationships with their boss or other staff, and the lack of flexibility. That flexibility piece, I think, is huge, especially around people who can work from home and things like that. And we can see it's really driving the labour market at the minute as well. Those things will all be helped by the tips I have outlined earlier and by proper processes and procedures in your business to manage your people. That will help all of the things on those lists. So how can you improve your retention? So good, and we've covered this, streamlined and efficient HR management. So, if you have a good HR processes in place, that will hugely help reduce some of those things on the list. So, if you have good appraisal processes in place, that will affect people feeling unappreciated or not listened to. If you've got good recruitment, onboarding and retention, then you'll have less burnout issues because you'll not have these gaps where one person's trying to cover the job of three. The work environment will be improved. Again, that like proper onboarding process, proper induction, people knowing this person is starting, people feeling communicated with in your business, that will really improve the overall culture and atmosphere in your business. Relationship with bosses, again, if you set out in your HR management to be a good communicator, people will come and resolve issues with you and they will communicate with you, and you'll not have these sort of bubbling underlying problems where there is relationship issues, and rather than getting them dealt with, the individual just leaves your organization. And the flexibility point as well. So if you have a good contract and handbook, you will have a flexible working procedure that sets out under the legislation that defines what you need to do, a sort of a flow chart of what the employee can do to apply for flexible working and how you adjudicate that. And again, if you've got a good procedure and you're following it and you're getting good legal advice on it, that will address that flexibility point as well. So if you're consistently using those policies and procedures, you're going to massively improve your retention. Regularly reviewing and updating contracts and handbooks. Again, this is something that sometimes businesses you're busy, we get it. But if you haven't looked at something and it's maybe 5 years old, there's a good chance there's a few things in it that are probably out of date and need updated, or there's policies in it that you maybe haven't thought about, but that should be included. I'm sure you've seen a lot of them recently. There's been some changes in the law around parental bereavement leave. Menopause policies are also being rolled out quite broadly in the employment area at the minute. So things like that you'll not have thought about, that are not in your existing documents, they'd really benefit probably from a review. I've covered the flexible working policy application. There'll also be policies and procedures around how to deal with employee unhappiness, for example, your informal grievance procedure as well as your formal grievance procedure. Mitigating risks of claims by taking legal advice when required. Again, that comes back to my point around a stitch in time saves 9, because it really will save you a lot of hassle if you have reduced the risks by getting legal advice in advance of taking action. run it past a lawyer. It is definitely worthwhile. Regularly monitoring employee happiness via anonymous surveys. That would be another recommendation of ours. We've seen that work quite well, because a lot of the times issues that you are completely unaware of that would be very easily resolved and improved upon just sail completely under the radar, because you're not being told by employees that it's an issue or that it's something bugging them. But a lot of employees will tend to put that kind of thing in an anonymous survey. So things like that may be beneficial, and then regular training as well. So again, anybody that's undertaking HR processes in your business, if they are trained and up to speed in this area, that'll be hugely beneficial. So apologies, I think I've gone a wee bit over, but that's the end of my presentation. As I said, we'll be covering any questions you may have at the end. I am going to now hand over to my colleague Nathan for his presentation on business immigration.
Hi everyone, so I'll just get my PowerPoint up here. There we go. All right, so obviously I don't have that much time this morning. It's a big topic, so I'm really going to have to keep it quite high level and just the basics. I appreciate some of you may already have knowledge about the immigration system. You may already be sponsoring employees. Maybe for others, you don't have experience of it. So I'll be keeping it pretty basic. One of the main things, obviously, is Brexit and the fact that previously EU nationals, you could employ them pretty much as if they were British or Irish. Now that's no longer the case. For British and Irish, it's fine, but for EU nationals, they'll need to have some sort of immigration status, whether that's pre-settled or settled status for people that were here before the end of the transition period, or some sort of a visa for people that are coming here after that. Because for people that are coming here after 31st of December 2020, in most cases they're going to be in the same boat pretty much as non-EU nationals. So this is a sort of pyramid I like to use just to briefly explain the various types of work visas. So at the top, what would have been called tier 1 before, this tends to be sort of for your business people, entrepreneurs types. So you can get visas to start up a business, or if it's more established, to run a business. There's also global talent, and that is in relation to a wide number of areas where you can be endorsed by various endorsement bodies, or if you've won a prize in a certain field, and there are all sorts of different fields, science and arts and all that, potentially you can get a visa on that. You probably wouldn't be encountering these sorts of people as much, because they would be the types that would be starting up their own businesses rather than coming to work for you, and in some cases their visa might only cover them to work for their business. The most common that you would be looking at would be what was called the tier 2, but is now the main one is skilled worker visa. So that's where you have a sponsorship license with the Home Office, and you're sponsoring this person to work for you. And as the name suggests, it's not just any role, it has to be sufficiently skilled and at a salary level that is high enough. There's also a few other types there. So you might have heard of intra-company transfer visas before. That's where you had maybe a parent company based in America or India or something like that, and you're looking to transfer an employee from that company to the UK company. That's now called global business mobility. So I'll go through some of the more recent changes in more detail later. There's also a few miscellaneous categories like ministers of religion, sports people. So the likes of your Premier League stars, they'll be getting visas, but it's a different process to the skilled worker one. Tier 3 for unskilled workers has never been opened. And the justification, I suppose, is that the government wants to have a high skilled, high salary economy. They don't want to have low paid workers coming from abroad and potentially putting down wages for British workers. That's the justification, and potentially in the past the justification might have been bolstered by the fact that you could get workers from EU. Now that's not the case, so whether or not that will be sustainable and if there'll be a change in the future remains to be seen. This is very much linked to politics, this this area, and it can change very quickly, depending on the whims of whoever's in power right now. But right now, the policy seems to be that it's only high skilled labour that they're wanting to prioritise, but we'll see how that goes. There's also tier 4 students, so obviously it'll be for the likes of people coming to Queen's or University of Ulster or things like that. Although that visa is to study, they can work part-time during term time or full-time outside of term time potentially, so you might be able to get students working for you part-time. It's also in tier 5, there's a few other miscellaneous categories. So you've got youth mobility, that will be like your backpackers. You would have seen there's a certain types of nationalities like Australians, Kiwis, Canadians get a certain allocation for people aged 18 to 30 to basically come here for a couple of years, and they can work or not. And you would sometimes see maybe the likes of Australians working in a bar while they're traveling on that type of visa. Or there's temporary workers. So that's where you might have seen the likes of the seasonal fruit pickers coming in on that. Or last year there was a shortage of HGV drivers and poultry workers, and there was a temporary exemption to allow foreign nationals to come in on these schemes. So they're very much short-term temporary work to fill gaps, and they're specific to certain industries. And of course, there's also, as I say, a large number of other visas that you could have that you could work on. Someone could have a family visa through being married to a British national. Someone could be of settled status, an EU national, things like that. So, but in terms of what you can do as an employer sponsoring people, it's going to be mainly the tier 2 skilled worker route. So, as I say, for EU nationals that were here already, prior to 31st of December 2020, they should be all right with their pre-settled or settled status. But for EU nationals coming after that date, they're in the same boat as the non-EU nationals. So that's where they'll be looking at getting a skilled worker visa. And I think that's what the real shock to the system has been for maybe employers that were used to just employing EU nationals without having to do anything. Now that's no longer the case. And as I said, not just any employer can sponsor anyone. You need to be registered with the Home Office with a sponsor license. And that involves making an application to the Home Office, providing certain documents, paying a fee. And as I said, not just every role can be sponsored. It needs to be sufficiently skilled. There's a list of occupations that are eligible. It also has to be at a sufficient salary, so that the general minimum is 25,600, although it could be more than that if the going rate is higher, or it could be less than that in some circumstances. For example, if the role is on the shortage occupation list, it could drop as low as 20,480, but it depends on the role and the candidate as to what exactly the salary threshold would be. And that shortage occupation list is updated from time to time. The government takes advice from the Migration Advisory Committee, and they update that with new roles that are decided to be in demand. For example, like the likes of computer programmers is on the list, but there are plenty of other roles that I'm sure there is a shortage of, but they're not on the list. So I don't know if the relevant industries aren't shouting loud enough to the Migration Advisory Committee or what, but that can be developed, and roles can come on the list or off the list. But there have been some changes that are actually positive post-Brexit in terms of this, which actually make the shortage occupation list not as big a deal. So it used to be that there was a resident labour market test. So you had to follow certain administrative steps to advertise the role in a couple of places and demonstrate that you were unable to fill the role with a British or Irish person, basically. And that's no longer the case. Now, it still does need to be a genuine role. And if the Home Office felt that this was a sham in some way, that could still lead to the visa being refused. But in terms of that administrative step, which I think a lot of HR professionals didn't really like, they'd already identified the individual. They didn't want to necessarily go through this process. That's now gone. Another big thing is the cap is gone. It used to be there was a cap on how many tier 2 general visas there were every month, And post-Brexit, it got to the point that cap was being exceeded. And that meant that the salary threshold went up because they would prioritize the higher paid roles. And that caused a lot of uncertainty. And that meant that roles that were on the shortage occupation list were better because then they were outside of that cap. Now the cap's been suspended. So it is quite good in that you should be able to identify in advance if the role is eligible in terms of salary and skills, and you shouldn't need to worry about the salary cap changing depending on how many other applications there's been. So I find that clients that already were doing this, that already were sponsoring maybe the likes of Indian computer programmers, actually find the changes to be very beneficial because it's been made a little bit easier for them. That the salary threshold also came down a bit as well. It used to be 30,000. But what I see is that for clients that weren't involved in this process before, that it's a new thing for them, it is a bit of a shock to the system, having to get a sponsor license and sponsor roles and being told that certain roles just aren't eligible for sponsorship. Another good thing about the skilled worker visa is it does lead to permanent residence. So after 5 years, they'll be going for indefinite leave to remain. And once they've got that, they don't need any more visas. And they could even use that to get British citizenship down the line as well if they wanted. And they can also sponsor their family members as well. Spouse, children can come as well. So one of the main recommendations we've been making for the last couple of years especially is look into getting the sponsor license, because it can take some time to get it. You've got to gather together certain documents, got to make your application. There's record numbers of applications going in, so it's going to take probably at least 2 months, could take more, could take less, but you know, it's not ideal if you've already identified someone and you're then only then starting to look at getting the sponsor license, because most people aren't going to be happy about waiting months and months for a job offer. So I would say that if you think there's even a chance that you might want to use it, you should be thinking ahead and getting it as soon as possible. It's not actually that expensive for the sponsor license, so the fees are there. So for a small company, it's 536. For a large company, it's 1,476, and that lasts you for 4 years. You would then extend it after that. Now, that doesn't include the visas. The visa applications would then be on top of that, and they can be expensive. But if you think there's a chance that you might need to use it, it would be good, I think, to think ahead and get it as soon as possible. So I just wanted to go over a few changes in the last year, just you might not be aware of. There's been a few new visa categories. So high potential individual, this is for recent graduates from non-UK universities. So there already is a graduate visa. So that's where you've got someone saying Queen's, they've graduated, they can go for a graduate visa, which gives them a temporary 2 years usually to remain in the UK, and they can use that time to work. And usually the idea is they get experience and then they get sponsored for a skilled worker visa after that. That's only for UK universities. So this route is for certain non-UK universities. Now it's only determined by the Home Office list of what the top universities are. So it's sort of like the global top 50 sort of thing. So, I mean, it's going to be quite niche, I think, but it could be useful for some people, you know, if they want to come here and start a business, or maybe say it's a small startup company and you've identified a recent graduate from a university in America or something, which is on this list. You can get them in on this without you having a sponsor license, and that would give you some time to get the sponsor license after that. Scale-up visas, this is really new, only went live at the end of last month. And again, quite niche, I think. It depends on if you're classified as a scale-up company, and there's a few requirements for that, which are on the slide. So you need to show that you have annualized growth of at least 20% in the previous 3 years for turnover for staffing, and at least 10 employees at the start of the period. So one of the main advantage to this route, I think, is that there's no immigration skills charge, which could save you up to £1,000 a year. it's also quite interesting in that although you need to initially sponsor the individual, they actually have more flexibility to switch roles after that, which I think actually is maybe a disadvantage for employers, because once they've sponsored someone, they actually kind of want to have the, once you've gone through the effort of sponsoring them, you don't want them moving elsewhere. So I'm not actually that convinced that this new visa category is that useful, but it could be for some companies, maybe like some small tech startups, maybe it might be useful. So as I said before, the intra-company transfer visa is now the business global mobility visa. So I think it's more of a rebrand and sort of combining of previous routes than it is something really new. And again, I think that it's not as good as the skilled worker visa because it doesn't lead to settlement. That is a big problem, I think. And it was sort of speculated that it might lead to settlement, but then at the last minute, it wasn't. So I think the main advantage of this route would be if you were wanting to get someone over for a relatively short period of time, like maybe a year, and you could get around certain requirements that there are with the skilled worker visa, like the English language requirement. So I have still done some of them recently, but I find the skilled worker visa is much better, and you can use that for employees at your foreign companies if you want it as well. Usually I think when they're bringing employees over long term, they want to have the ability to stay here long term. So I think that's a problem with this visa category. And then just briefly, it used to be that you could get an investment visa if you had £2 million in spare change that you could invest in a UK bank. You could essentially buy yourself a visa, and you might have seen that with certain Russian oligarchs, getting their children into private schools, Eton and all of that. That very quickly was abruptly cancelled, connected to the Russian-Ukraine war, and there wasn't even the usual 21 days notice. It was just cancelled to avoid a closing down sale effect. But that just means that there's no new migrants on that route. And there has been some talk that they will be looking at this again and coming up with some other route for high net worth individuals to get visas, but just interesting that was just so abruptly removed. So right to work checks is going to be important to you regardless of whether you have a sponsor license or not. And that's because knowingly hiring illegal immigrants is a criminal offense, or negligently hiring them is a civil offence that can lead to fines of up to £20,000 per worker and also reputational damage. So what you need to do is to get a statutory defence by conducting valid right to work checks. So that means obtaining the ID, checking it, and taking copies. And you would do that for everyone, British as well. That's one of the main reasons why employers will get your passport when you get a new job, because they're wanting to have it on file that you've got the right to work for them legally, so they avoid any liability there. And obviously it would be discriminatory if you only did that to people that sounded foreign, so you do it for everyone. Now, it used to be that you could do a manual right to work check on the BRP, which is like a credit card sized document that is your visa. That's no longer actually allowed. You have to do the Home Office online check. So you can still check British and Irish passports okay manually, but for people that have visas, you need to do this online check with a share code. And there's also an employer checking service, which you can use, for example, if someone had an application that was in the system, hadn't been decided yet, you could verify that they have the right to work through that. One good thing is that change is not retrospective, so it's only from 6th of April this year onwards. You don't need to recheck people that you had already done the old-fashioned way. So basically, British and Irish employees, you can still do the manual check. Now, it used to be, well, I suppose it technically still is the case that there was a COVID exemption that you can remotely check the ID, maybe by a Zoom call or something like that. That's actually ending on the 1st of October, so this Saturday. So it's back to that COVID exemption is gone, and it's back to the manual checks. You can also use identity service providers to do that, although they would charge a fee for that. So in most cases, I would have thought it would be easiest to just check someone's passport for free. first question is quite long, so I'm just going to summarize it. Basically, it's saying, do you need to have the candidate identified before you get the sponsor license, or can you just get the sponsor license first? Which one do you do first? So you don't need to have a candidate identified to apply for a sponsor license. You can get one on the basis of you think that you might need it in the future. If you do have a candidate identified, then you'll want to, that will form part of your application, because you need to demonstrate to the Home Office why you want the sponsor license. And it can be to your benefit to disclose that you've got a candidate identified, because potentially, as well as granting the sponsor license, at the same time, they could give you a certificate on the license ready to go. So you can, it just saves the delay. So no, you don't have to have a candidate identified. And I think it's good to actually think about it in advance rather than waiting for someone to come along. But if there is a candidate, then yeah, you do identify them.
Nathan, just on that area, can you give any useful tips on how companies might identify those candidates in terms of who they would work with to identify those candidates overseas?
Well, that would be more of a recruitment agency type of thing than a legal one. But I think there will be agencies out there that can help with that. I suppose it depends on the industry. Like with software, computer programmers, for example, I see all the time Indian applicants, very common. I don't know, that it just must be the way their education system is there. They're all trained in that. So, but I think it's going to be up to you to identify the candidate. Really, no one's going to match them for you. But once you've got that identified at an early stage, you'll want to make sure that they meet the requirements in terms of salary and skills and all of that, because there's no point going through the process if it's not going to be successful.
Just finally on that as well, are we getting any sense from the Home Office that there's going to be any relaxations in terms of the English language requirements? Because I know that can be a bit of a barrier, obviously, as well, in terms of recruitment.
No, there have been relaxations in terms of the salary and in terms of the roles in the last couple of years. There hasn't been in terms of the English language requirement, and I suppose you can see why. It's going to be a government policy that they want people coming over here that can speak English. Now, the exact level of English language will depend on the visa you're going for, but for a skilled worker, for example, they need to be proficient to level B1, and they need to prove that if they're doing a test, they need to prove that with speaking, reading, writing and listening, the 4 components, and it needs to be in one of the approved test centers. I find that it's not that high a level. Like, you sort of know yourself when I'm dealing with the applicants. If I think they'll have an issue with passing the test, you can sort of tell, because their English isn't very good. So B1 isn't like a native speaker or anything like that, but there is a certain level of proficiency there that is required to get the visa, for the skilled worker visa. While, for example, with the settled status, pre-settled status, there is no requirement. It's basically just based on your residence in UK and being an EU national or family member of one. And then there was one other question here, and this is a good one. Are there any significant discrimination risks by declining candidates who do not have the right to work in the UK, as they require sponsorship at the beginning of the application process? If so, how are we best to manage them? So yes, as Suzanne had mentioned earlier about your adverts and things like that, and you definitely want to avoid being discriminatory, either directly discriminatory or indirectly. But at the same time, it is a little bit different here in that, as an employer, you can only employ people that legally have the right to work for you, right? So for a British or Irish national, that's fine, but for anyone else, they're going to need some sort of a visa. And that may mean that they would require sponsorship from you, and that may or may not be possible. They might not be a role that is eligible for sponsorship. And if that's the case, obviously you can't sponsor them, so it's not going to happen. I mean, that being said, I suppose you could be in a position that you've got someone that you could sponsor, or you've got someone that doesn't need sponsorship. And in that case, would it be discriminatory to pick one over the other? Well, previously there was a resident labour market test that would have given you a good justification for saying no. You actually have to go for the resident labour before you go for the foreign labour. Now that that's gone, could there be arguments that should be considered? I mean, there's other things to consider as well. There's the costs and admin of doing this, getting the sponsor license. I think it would be a difficult argument for someone to make in that case. But I think basically you just want to think about these things and consider sponsoring someone. It may or may not be possible, or an attractive option for you. There are things you could do that could make it more attractive. Like, there are costs associated with it, but sometimes you might get it that the employee will either pay these costs, or some of them directly, or you could enter into a clawback agreement with them whereby if they leave within a certain amount of time, you could recoup some of the costs, and some of the costs actually would automatically be recouped from the Home Office anyway. Some of the main costs would be the immigration health surcharge and the immigration skills charge, which are basically taxes. And if the employee left, say 1 year into a 3-year visa, you should actually get the other 2 years reimbursed automatically anyway. So that can make it a little bit more palatable. But I appreciate that it is, it's much more of an ordeal to do this than it would be for just hiring a British or Irish worker that you just check their passport and that's that.
Nate, I'm just conscious of time, and this is such an important topic area. Just a suggestion, would you be happy for people to contact you directly to answer some of those queries just following this webinar, those that maybe have been on the webinar? Or
yeah, I'm happy to have a quick call with anyone, within reason, or, answer the odd query. Obviously, when things get more detailed, it might be at the point where you would need to discuss fees and things like that. But I'm happy to have a call with anyone, just to have a chat and see what your situation is and if I can help.
Okay. There's just one other question I think Michael had put in the chat function earlier. If he wants to bring someone in-house that has been working for him for 6 months via a temp agency, can they transfer them across without having to advertise the role? And Suzanne, maybe you might answer to that one, please.
Yes, so I probably need a wee bit more detail, Michael, about the arrangement, because there's a couple of scenarios that could exist there. If you have, if you're not the direct employer and they're employed by another organisation providing services to your business and you're moving those services in-house, there may be TUPE implications. I'm sure a lot of you are familiar with the reference TUPE, but it's a complex piece of legislation and it covers things like service provision change, where businesses are bringing something that they had previously outsourced to another organisation in-house. And that would apply potentially. However, if you've actually been the direct employer, so you've been introduced, this individual's been introduced via a temp agency, but you've been directly employing them, then it's more probably around sort of changing your terms and conditions with that employee. So it may be that they're temporary there. So ultimately, those types of variations of contract are probably going to be attractive to that individual. For example, if they're on a temporary contract and you're offering them a permanent contract. So, you can look at that. In terms of advertising, just touching briefly on that point, and again, I can cover this with you more directly. Best practice really is to advertise roles. That's to protect you as an employer in terms of your equality and any arguments of unfairness or discrimination where there hasn't been either internal or external advertisements for vacancies. especially if there's potential risk that your organisation will at a later stage go into a redundancy type situation. Roles not being advertised can come back to bite you, because if, for example, you've taken somebody in without a proper recruitment process, but 3 months later you're having a redundancy exercise, and individuals bring up that a vacancy was recently filled without a proper process, that can cause difficulties. So best practice is to advertise internally and externally, and to do so fairly, but it's not always done, and it's then, I suppose, for you as an employer, balancing the risks and considering where you're at as an organisation, and what those risks are. But again, I'm more than happy, Mary, I'm mindful, obviously we've run out of time, but I'm more than happy to pick this up directly with Michael if he wants to drop his contact details to me. I'll get in touch with him.
Okay, thanks for that, Suzanne. Folks, I think that's been really informative and covered so many different areas there. And thanks so much to the CF4 team for giving so much useful advice and tips. There's lots of really up-to-date information there, especially on that immigration process too. I suppose there's lots of useful ways, I suppose, that aren't the most obvious ways that companies can bring in migrant workers. And we'd be delighted to continue working with CF4 Law on this area and answer any of those queries as well. Listen, folks, thank you very, very much for everyone for your attention, and especially to the CF4 Law team, and hopefully have a nice day. Enjoy the rest of your day, folks. Thank you.